And then returning back to the gun trusts, I guess looking at those benefits again. So it ensures that gun owners and their relatives comply with federal firearm legislation. And I think this is, as we've seen, a very big component, because there's a lot of moving parts in terms of people that can have them. There's restrictions on or regulations on when it can be transferred. And so in that case, you're really, you don't want to run into a situation where somebody has accidentally committed that felony. And it's also going to be very easy for someone to accidentally commit a felony. The other thing is, a lot of these are cases that you might be transferring to somebody that you don't know, or you haven't asked them whether they're a prohibited person. It hasn't come up. And so due to that, the trustee might not know, the gun owner might not know. And so in order to avoid that, gun trust can really provide, that benefit. In addition, just like all trusts, it can help effectuate the gun owner's, desires. Guns are incredibly valuable. They can also hold a lot of sentimental value to people, and so making sure that somebody can pass that down to whoever they want, or to the person that they want to, can be a very important thing for the client. Can mean a lot to the client, and so then it can be very important to make sure that is done correctly. And as I had said previously and have reiterated, it allows more than one person to possess that firearm.
With respect to more than one person, you make it clear, settlor and all trustees, and you can name co-trustees to increase the number of people that can possess and use the firearm.
Yep, so you'll have...
What about beneficiaries? I mean, usually in a trust, what if your purpose of the trust was to allow a beneficiary to use this gun? Okay, or is it just for dispositive reasons that you list beneficiaries?
Great question. It really seemed that it's for dispositive reasons. When I was doing my research, because I had that same idea, that it would make sense that you would have a beneficiary be able to use the firearm. I mean, they're the beneficiary of the trust, but that really doesn't seem to be the case. It really is that beneficiaries are considered separate. The trustee, as the person that has a fiduciary duty to the beneficiary, and as the person who's managing the assets of the trust, that they are the ones who can use that firearm, but that they are the only ones who can. So if you have an idea of there are certain people you want to be able to use that, make sure that they're included as a trustee.
I have a question. So normally a trustee does not get to use the assets of the trust.
Yeah.
If I leave the house for my kids as beneficiaries, I think it's self-dealing if the trustee gets to. So you're saying here that really the trustee is using.
Yep, exactly.
And then I'm supposed to put all the social security numbers in the document? Looking at your tips.
Yeah, I see the tips.
You can put XXX.
You can put XX. Yeah, exactly. You can do that. It's, I think, something too, if you're really going to want to make sure, I mean, it can be a good practice point to at least in some document have them, even if it's not, even if it's not going to be the trustee that you can't, or the trust document that you can't to everyone. But I think the idea is that you want to make sure that you have your social security numbers, because invariably when you're trying to transfer that, the firearm, you're going to need to know that information. And so, you're going to want to make sure that it's on hand, and potentially that the trustees also know where they can find it, so that they can.
So if you have a young settlor who has a couple guns, but then wants, two questions I guess. One is, really does want it to be dispositive to her children. So that would be different. I mean, the trustee doesn't necessarily have to have any reason to use the gun. And then the other one would be, I own 3 guns now, but I'm really going to become a big collector. And I don't know what guns I'm going to own when I die. So then do you do an attachment, an addendum to list the future gun? You can't just say, I have these 3 guns, set forth an attachment, exhibit A, and And then any other guns that I own as of the time of my death. You don't
Right.
really like that part, probably.
No, that would probably, I think the federal government would probably frown on that. But what I would do is, something, I would probably have a list that, that said, these are the guns I have currently. I can amend this list at a later time to include any, guns that I possess in the future.
Amended exhibit A1 and attached to the revocable trust of so-and-so and so-and-so dated, and then just keep up your First Amendment, Second Amendment, Third.
That is, I think so, that's probably, or, that's probably somewhat similar that I would do, or I would, include, I would just include, or I guess potentially, depending on how you want to do it, maybe you wouldn't even include necessarily a list, but instead, well, I guess you'd have to. Otherwise, I was going to say, when you bought the gun, you just do a, assignment to the trust
By the trust name.
by the trustee, or I think the better way to do it would be to actually have the trust be the one to buy the gun, and then you're acting on the trust's
You put in
behalf.
all the guns that you have now into the trust, and then subsequently you have the trustee buy the gun.
Maureen, why would you want to put guns in the trust that aren't controlled? It's only Title II guns that
Right.
are controlled. Not that many people are out collecting multiple machine guns.
She had a grenade launcher.
Yes, we have a grenade launcher, yes, but
Well, you can see that I don't know a lot about guns, so all deer hunting rifles are type 1.
Would be type 1. Yeah, there's it's a very limited number of guns that are considered Title II, and yeah, it's really limited to short things like sawed-off shotguns, machine guns, things like that. Yes.
How public does the notice to the chief, law enforcement officer become?
I guess I would say it doesn't really become, that it doesn't become.
not a public record?
It's not a public, I guess I don't view it as a public record, no.
I mean, maybe it's not public record kept, but it might be discoverable by making an open records
Well,
request.
you would think so.
Yeah.
Why would that be?
I mean, it sounds like a dangerous world.
And, and that is a concern. That part wasn't necessarily touched on in the literature that I was seeing, but that is definitely a concern. I think, to some extent, there's the question of how much would someone, it's something that potentially you could get through a public records request. There would be, that argument of when that happened. But is someone really going to accept, somebody really going to be searching for, or going to be asking for a public records request for that? But I guess. Yes.
Are there time deadlines that people with felony records can absolve themselves by either doing the trust or selling their gun?
It sounds like the court was really saying as soon as possible. I know, I can't think of the number off the top of my head. I know there is, but it's measured in days.
And then is there any trust not strong enough, legally strong enough to clear someone of their possession of a gun if I have, if I'm not supposed to have one?
So I guess the only one that I can think of is if you chose to use a trust that was designed to allow the grantor and the trustees to use the firearm. So if that type of language was in there and you were using it for a different purpose, so you were using it to get it out of your hands, pass it on to a beneficiary, that's where I would be really concerned if those types of provisions were in it. But if you had it set up so that it said, I'm the settlor, I have no rights. As soon as it goes in the trust, I have no rights to use this gun. It is, possession of the trust. This is what's supposed to happen to it. And there's never a question that you can revoke the trust. That's where I would say that's when you're safe. But if you become a felon and you're saying, okay, I'm going to put it into a gun trust, but it's revocable, I have the power to, fire it, even if it's not kept at your, location is kept someplace else, I would say that's where you would run into trouble.
Do you know how Title II is being used with regard to bump stocks? Are they classifying them as any other weapon?
I haven't seen, at this point, I don't think bump stocks are included in the Title II.
What kind of accessories that would make a
Did that
weapon?
all go through or not? I don't know if it did.
Right, and so I don't think that specifically went through. It really is, they really do keep it fairly narrow as to what's included in Title II, and so you really are looking at silencers. That's definitely one that's in, but it doesn't really seem to be saying, but it's not saying silencers and other accessories to the firearm. I guess the only question would be, under Wisconsin law, does a bump stock count as something that's converting it into a automatic weapon? I guess my understanding would be that wouldn't necessarily do. I don't necessarily think that would count it, just from my research and from my understanding of how bump stocks work. But I think that would be an open question, and considering recent events, I think you could see that being added to a Title II list. And so, just from, I guess, practical, and so one other thing before we get into the practical component, how long can a gun trust last in Wisconsin? Theoretically, a gun trust can last forever. We don't have the rule against perpetuities in Wisconsin. We have 700.06, which is one of the statutes that I was referencing for including, they are relevant to trusts, but not included in 701. And basically it says that if you have the power of alienation, if you don't have the power of alienation for longer than the permitted period, then that's invalid. The permissible period is life or lives in being plus 30 years. And really the rule in alienation is, can you transfer the property? So as long as you would set up the trust correctly so that a trustee, a collection of trustees, could transfer that gun at some point, you could have a gun trust that theoretically lasted, as long as you wanted to, that theoretically could last forever. And so just practice tips, and I'll go through these very quickly because you do have them as well. You want to make sure that the gun trust specifically addresses federal laws concerning proper possession and transfers of firearms, the state and regional gun laws where the firearms are located, and also where they're going. I think this is especially relevant in our area of Wisconsin because we can see clients where hunting is very popular, but also we're right on the border with Minnesota, and we're very close to the border with Iowa. So theoretically, you could be seeing guns crossing state lines. In addition, make sure you know about the legality of the weapons at each point, the proper method of completing a transfer, and the eligibility of the fiduciary and successor fiduciary, or the eligibility of the fiduciary, successor fiduciaries, because this is especially true in cases where you're planning your trust to last for a very long time, so you're going to need to have additional fiduciaries. One way, there's two different ways that you can deal with this. One is to have a list of people that you want to have as fiduciaries. Other is to have a method for selecting new fiduciaries. And I guess a third way would be to actually appoint a trust protector, or appoint someone who is going to determine, or an entity, who's going to determine who your fiduciaries are, or who your trustees, in the future are going to be. You also will want to make sure that you are following the domicile, or the correct procedure in where the trust is located, and also that you'll want to make sure that you include a provision that if the grantor would become a prohibited person, that they are going to lose all rights, to possess that firearm, because you don't want them to later on become a prohibited person and then commit a felony. And you want to make sure you have the same thing of that with trustees. So make sure that your trustees if your trustee were to become a prohibited person after the creation of the trust, that they would have considered to have predeceased, either predeceased the grantor, if that's the way you've got your trust set up, so that they only come into effect when the grantor dies, or that they are removed as trustee. However you want to do that, but just make sure that they also won't run into those issues as well. Just other contents. It can be revocable or irrevocable. It just depends on your goals and what you want to accomplish with the gun trust. It should include specific references of intent to comply with the Gun Control Act, the National Firearms Act, any other federal, state, or local laws and administrative rules that deal with the possession of firearms. Make sure that your successor trustees are able to actually possess firearms themselves, and make sure that you have multiple ones just in case. The other thing to keep in mind as well is that you want to make sure your trustees have all the broad powers that they need to actually carry out your wishes or to comply with federal laws, including how to transfer the firearms and questions about compensation. If they have to personally transport the firearm to a new location, do they get compensated for that? Those are questions that you'll want to consider and things that you'll want to discuss. And finally, you'll also want to include a catch-all provision for saying what happens if no one is eligible. For some reason, everyone in the trust becomes a prohibited person. In the literature I saw, the recommendation is appoint a 501c3 or some kind of organization that is eligible to take the gun and dispose of it. For example, the National Rifle Association is one that was specifically mentioned in the literature as an organization that is allowed and has the capability of taking the gun and disposing of it. Because you don't want to reach a situation where no one's allowed to take it and you have no way to get rid of it or get it out of the trust. I also included a checklist. One explanation, make sure you send a certified copy of your disclosure to the chief law enforcement officer by registered or certified mail. They are not required to send you back confirmation. And considering that is a necessary requirement that you notify them, the last thing you want is that there be any question later on about whether you did, and then have the chief law enforcement officer not be able to, provide evidence that they ever received that notification. So with that, I'll end my presentation. If anyone else has any questions, I can definitely answer those too.
Questions. If you have a gun trust that precedes the 2016 changes, I assume they're all grandfathered in?
Yes.
Okay.
So.
And then the second question is, with regard to gun trusts that are designed and legal and appropriate in the state of Wisconsin, what happens if the grantor or the person in possession moves to Minnesota?
So if it,
Or Iowa.
right, or Iowa. So if they move to Minnesota or Iowa, that's something you're really going to want to, you're really going to want to double check exactly how that applies, because with your language, it should say, we've got the intent to comply with all federal laws. It probably I don't want to say it's probably going to be fine, because it's really going to require, looking at the laws in effect at the time that you're making the transfer. But I think the biggest concern you'd have would be a prohibited person. But you've also probably got language in there saying, if they're a prohibited person under any of these laws, they're not okay.
Okay, thank you.
Thanks, Will.